Well, yes. The first most important thing is, was I at City Hall, yes or no? Was I outside City Hall?
Yes.
Do you have evidence of that?
There's cameras on City Hall, yes.
Okay, do you have pictures, any evidence here? Have you sent it to the court?
No, this is not that type of a hearing.
I'm also giving you the order, and this will be added to your conditions. Do not threaten, harass, annoy anyone at City Hall. Do that.
I can't switch at the moment, and that's the issue.
Okay. You can, and you will, or you will not be in compliance with the condition.
Today we're dealing with a defendant who is very stubborn and wants everything his way. And honestly, it's kind of funny how confident he is, considering he's a walking problem for the community. He's acting like he's trying to negotiate a gym deal, not standing in front of a judge who decides whether he goes home or to jail. And the crazy part? This whole issue is tiny. Like something you could write on a sticky note. It should have taken 30 seconds. Instead, this guy turned it into a full court hearing because he refuses to deal with the smallest inconvenience, switching to a different GPS ankle monitor. He's fighting harder over a monitor than over his actual case. So let's get into it. The judge asks what needs to be done. The only change is that his GPS needs to be switched to the device the court now uses. That's it. But the defendant argues back. He says he was told he could keep his old GPS company, he's almost at trial, and he doesn't want to pay for a new one. He says switching now makes no sense. Then the judge asks about the reason behind this concern. Police say he was seen at the local city hall, taking pictures and recording people. He denies it, saying he only drove past and went behind a nearby church. But the problem is, his GPS already showed he was at City Hall. So now he's arguing with the officer. Do you have proof? Do you have pictures? Have you sent anything to court? But the officer explains that people recording buildings and following employees can be a warning sign, especially when cases in the past show that behavior before targeted violence. They're not charging him, but they are concerned. The defendant says it's ridiculous, that nothing happened, that he needs to pass by that area anyway, and that the GPS system is slow and inaccurate. The judge listens. The state says the charges are serious and they need a GPS they can monitor in real time. And if money is the issue, the state will cover the cost. So the money excuse is gone. But the defendant keeps going. He starts arguing that maybe he shouldn't even have a GPS at all. He says the old monitor doesn't help him or the state. He says it's apparently inaccurate, which turns out to be the worst thing he could say. Because the moment he claims it's inaccurate, the judge sees the opening. The officer checks the notes and confirms, the GPS says he was at City Hall. Exactly where he said he wasn't. He tries to spin it as I just drove past or the GPS ping wasn't perfect, but at this point, he basically admitted the device doesn't work well, which means the judge has to switch him to the new, more accurate one. So the judge says, okay, if the old GPS is inaccurate, then you definitely need the new one. You will switch. That's the order. And then the judge adds a new rule. While you're on bond, do not threaten, harass, or annoy anyone at City Hall. If you're following people closely and recording them, that counts as annoying them. Don't do it. Basically, act normal or go to jail. And that's when it becomes clear, the defendant walked straight into his own defeat. He argued so much that he gave the judge the exact reason needed to order the switch he was trying to avoid. He talked himself into losing.